We're getting some breaking news coming in from none other than the Supreme Court of India. And this is the Supreme Court dictating its order in Nupur Sharma's plea to club the FIRs or multiple FIRs that were filed against her. Now, the court says that the live threat on Nupur Sharma has persuaded the court to rethink its order, and that's why it passed the July 19 order, in which there was a notice, you remember, that was issued. There is a process of the dictation of the order which is underway. We are getting you minute-by-minute details of what is transpiring at the court right now. Let's just take you back in time a little bit. You remember what had happened when Nupur Sharma had approached the Supreme Court. The Supreme Court bench had some very scathing and, I must say, some controversial observations to make, including the fact that the court held her responsible for the sort of violence that we were witnessing across the country. They also said that Nupur should have not made such kind of statements. The application before the court is that if there are multiple FIRs against a person, they should be clubbed together in one go, and there should be a single trial that should go on. That is in many ways the ratio of multiple constitutional cases that have been passed in the country. Such applications are moved under Article 32 of the Supreme Court of India, and Nupur Sharma did the same thing. She moved that application and she said that club all of these FIRs together. After those scathing observations of the Supreme Court, the petition was dismissed as withdrawn. The lawyers took back the petition. However, once again, with fresh grounds, new grounds, persuading the court that there is a fresh threat to her life, the petitioner, Nupur Sharma, and her lawyers went to the court and said, look, these are the conditions on which the client, Nupur Sharma, is right now managing. These are a very real threat to life that she is facing right now, and she cannot go to multiple parts of the country to seek any kind of justice or cooperation with the police authorities. In the last hearing, the court took up the matter. There were notices that were issued, and now the court is in the process of dictating that order. What are the possible things that can happen? The most obvious thing that can happen in a scenario like this is the court tells you that club all the FIRs together. This is a very ordinary relief which is available to every accused in this country. It is also the ratio of the case of Nanda Bharti case. It is also the ratio of multiple cases, including the constitutional bench judgment of the Lalita Kumari. Various constitutional cases in the country have said that you're an accused. You have a right to free and fair trial, and the process in itself cannot become the punishment. Keeping all of that into mind, usually in cases like this, the Supreme Court gives a marginal relief to an accused, that you can club all the FIRs together. There's a single trial that can happen, and if the crime, if the action which the alleged crime has taken place is same in all the FIRs, then there is no point of having multiple cases at different locations. So the most obvious thing is that she can get this kind of relief, that all the FIRs will be clubbed together. That in no way means that Nupur Sharma will not undergo trial. The trial will go on. She will have to depose before the court. She will have to record her statement. Witnesses are going to be examined. The criminal process against her will continue to go on. The clubbing of FIRs, what it will do is that suppose there's an FIR in Uttar Pradesh, another one in Maharashtra, another one in Rajasthan. She doesn't have to go to all these places individually and depose before a court of law or before a police authority. Swapnil Kothari, who's a lawyer, is with us on the broadcast. Good afternoon, Swapnil. Always good to have you. Clubbing of FIRs in many ways is a right which is available to most accused. What are the factors that the court takes into account before passing an order of this nature?
Well, Anusha, what happens generally in these cases is that the court will look at the fact that it is not inconvenient to you. Rather, it's look at it positively, that it's more convenient for you to attend it at one place, given that there are several FIRs across the nation. So if it's there in Delhi itself, you go to a Delhi High Court, or even the Supreme Court can say that, okay, please club these FIRs, let her be tried in Delhi itself. And for that, obviously, the court will look at the fact that she does not have any bodily threat or harm or anything of that nature, which she has got in this case. So in most of the cases, it is imperative, especially better for the court to give that relief to her, because it means nothing. It is a very simple procedural relief that they are giving. They are not absolving her from any arrest or anything of that sort.
Yes.
So if it was anybody else in her position, I think they would have easily got it, but I think today itself the court should be a little bit more magnanimous and easily give that to her, because it's a very simple relief to ask for. She's not saying that please spare me from any legal trial or spare me from any arrest, which the court had at last time until today. The court had said there'll be no adverse action taken against her, but today they'll lift that up. Obviously, I'm sure they'll do that if they give her the relief that lest she be tried in Delhi itself, where I believe she wants to be tried.
Yeah.
So I don't know why she has not gone in the past couple of days since that order which said that come to us on August 10.
Yeah.
She should have gone to the Delhi High Court and got this done itself, so as not to bother or approach or wait for the Supreme Court. But now that she's not done that and she's now at the mercy of the Supreme Court, let's hope for the best for her.
And I want to just put out some more details which are coming in from the Supreme Court. Ashwini Dubey, who's a lawyer, is also with us on the broadcast. Ashwini and Swapnil, please continue to stay with us. The court says that we entrust these FIRs to one investigation agency for the purpose of investigation. Court has begun dictating the order and the process of dictation of the order is underway. We're not going to jump to any conclusion till the dictation of the order is over. But as Swapnil was pointing out, this is a very ordinary process of law, a remedy which is available to most accused. Ashwini, I'm coming to you. T.T. Antony versus State of Kerala, where it was held that if the crime is a single crime and if you have FIRs at multiple places, it is in many ways violation of your Part 3 fundamental rights, Article 20. And that is the reason that in most instances the court chooses to club the FIRs.
Yes, the law is the same because on the same allegations, number of FIRs are filed at different places under different police stations, and the constitutional courts have duty to club those FIRs. The T.T. Antony case is clear, followed by various other cases.
That's right.
Recently, what has happened is on the behalf of the certain complainants, some complaints were filed before various police stations on the similar cause of action and similar FIRs was registered. So finally approached to the Supreme Court, and Supreme Court, the law says that on the similar kind of allegations, number of FIRs should not be filed, and it is a violation of a fundamental right of an individual. So the Supreme Court made it clear in T.T. Antony case, followed by Arnav Goswami's case, Amish Devgan's case, and also Rohit Ranjan's case, and Jubair Ahmed's case, that if number of FIRs are filed at the behalf of the state government and the complainant are same, allegations are same, then those FIRs should be clubbed and it should be entrusted to the one investigating agency. The law also says it would be the first, where the cause of action has taken place, the cases will be transferred to that place. So here if we see, the first FIRs were registered in Delhi. So Delhi, in fact, the court may, on its own wisdom or following the due principle, may transfer the investigation of the FIR, because look, the investigation of the FIR, quashing of the FIR, two different things. Investigation, when the FIR is registered, then the police or any investigating agency is duty bound to take it to the logical conclusion.
Yes.
So the logical conclusion has to be done by the agency if the similar FIRs are registered to the same place. This is the law. So ultimately now court will, so now the court will transfer it for the investigation, and if tomorrow it comes out...
Ashwini, I want you to stay with us on the broadcast. Swapnil is also with us on the show. I'm just going to reiterate all the developments that my colleague Ananya is reporting from the Supreme Court. He's tracking the hearing for us. I'm going to reiterate what has been said so far in the process of dictation of the order. These are not conclusion, but a process in which the court is dictating the order. The court goes on to say that notice was issued as to why the alternate prayer shall not be entertained. The court further records the submissions that have been made. The court goes on to say that with regard to the quashing of the cases which have been registered against her, we are of the view that the counsels can approach the Delhi High Court for seeking of the quashing of the FIR. So there were multiple prayers that Nupur Sharma had made before the court. One of them was that there is no merit in the case which has been filed against her, and the FIR should be quashed for being devoid of any kind of merit. The court is saying for that remedy, you might as well go to the Delhi High Court, something that Swapnil was also mentioning some time ago. We'll just continue tracking all the details. Swapnil, coming to you immediately. As far as the quashing of the cases are concerned, what are the remedies or what are the steps Nupur can take before a Delhi High Court?
Well, Anusha, it's good news for Nupur Sharma. The FIRs have all been clubbed by the Supreme Court. Now, as far as the quashing is concerned, the Delhi High Court, may take a view that the comment was made as a response to the comment made by one Mr. Taslim Rahmani. It was all in the heat of the moment. I don't think that anybody intended to insult someone or anything of that sort, or that is a view that the court might take and may just end up saying that this is just, one of those road rage kind of a moment where, people just get out of the cars and abuse each other. And, one shouldn't take too much notice about it and kind of quash the FIRs. But to come to that conclusion, the court will have to examine all the details, all the evidences, which I'm sure they will. And it will all depend upon how vigorously Nupur Sharma's, advocate argues this point, and I believe he should be arguing this point, because if it was made during that heat of the moment, then I think these things should be quashed. But I don't see that coming very easily.
It is a big relief for Nupur Sharma, all the FIRs to be clubbed. That's what the Supreme Court of India is saying. There were two major prayers that she had made before the court. One is that all the FIRs should be clubbed into single place so that she can cooperate with the investigation, depose before the agency. And second, that the case prima facie has no merit and hence the FIR against her should be quashed. The Supreme Court is of the view that they have agreed to club all the FIRs together. However, for quashing of the FIR, Nupur Sharma is free to move the Delhi High Court. It's a big, big relief coming in for her. For any accused who's dealing with multiple FIRs filed in different parts of the country, a simple process of clubbing of FIR leads to a huge process which serves as a punishment in some way being thwarted. Cutting across to Mr. Majid Memon as well, who's with us on the broadcast. Mr. Memon, the Supreme Court has agreed to club all the FIRs filed against Nupur Sharma. Your reaction?
Well, under the criminal law, if an offense has been committed by an accused person and for one same offense, different FIRs are registered in different parts of the country, in different states, then certainly a relief can be sought. And the court has, Supreme Court has considered it on merits that the accused must not be made to run from state to state for same act, alleged act, which is an offense. Now, without going into the merits, the Supreme Court has not spoken anything about the quashing. As far as the quashing of the FIR is concerned, quashing of the allegations are concerned, she may be given a liberty to approach Delhi High Court, where it would be examined. But as far as the clubbing of the FIR is concerned, it has been granted without going into the merits of the allegations.
Absolutely. Mr. Majid Memon, thank you so much for sharing your view with us. Ashwini ji, I'm coming back to you. Manojit Mandal of the TMC is also joining us on the broadcast. Mr. Mandal, thank you so much for speaking to us. A relief for Nupur Sharma, the FIRs have been clubbed.
I think we will definitely go by the order of the Supreme Court. Will decide and how it goes, and then the state government will take a call.
Right.
What is there to comment on it? I mean, what she said, Ms. Nupur Sharma, I think should be perennially condemned. She can't say what she said. Whether this is a crime, offense, how intense the offense is, that will be decided by the court of law. But she is definitely, whether the court quashes FIR, she doesn't get any punishment, she remains, I think, this will be treated as a moral culpability, and she will have to answer to this nation why she said what she said.
Well, Manojit, as you said, the process of law will continue. It is only about clubbing of all the FIRs together. Ashwini Dubey continues to be with us on the broadcast. He's a lawyer. Ashwini ji, I'm going to argue merely on the merits of the case. However grave an offense may be, however serious charges there may be against you, every accused has the right to move before a superior court and seek clubbing of FIRs. The simple process or the simple remedy was a very tricky one for Nupur Sharma.
Yes, initially this should have been done because, as you rightly pointed out, that the TP Antony case categorically held that the filing of another FIR for the same cognizable offence has been alleged in the first will be violative of Article 22 and 21 as well as Section 300 of CRPC. So, clubbing of FIR and quashing both are the different things. But for the quashing of the FIR, the essential conditions are that in cases where the allegations made against the person are proved to be false in entirety.
Yes. Ashwini, I'm sorry, I'm interrupting you for a second. I'm just going to read out what the latest update is, that all the FIRs have been clubbed and Delhi police shall ensure that Maharashtra and various other FIRs shall be investigated together. So it's the Delhi police which is going to investigate the entire matter, since the court has already taken cognizance of the threat to the life of the petitioner and specific instances have been cited. We direct that all FIRs be transferred and clubbed to Delhi police. That's the big development that we are confirming here on CNN News 18. Not just that all the FIRs have been clubbed, Delhi police is going to investigate the matter. Takeaway number 3 is the fact that if she wants to move an application for the quashing of the FIR, which means Nupur Sharma says, prima facie, there is no case against me, she can go to Delhi High Court and argue on the merits of the case. This is a relief coming in for her after a very stern position that was taken by the Supreme Court in the earlier hearings. Vinod Bansal of the VHP is also joining us on the broadcast. Vinod जी बहुत बहुत शुक्रिया हमसे बात करने के लिए. फाइनली नुपुर शर्मा को एक रिलीफ मिल गई, एक ऐसी रिलीफ जो बहुत सारे अक्यूज जो हैं जिनको कोर्ट से मिल जाती है, लेकिन उनके लिए काफी मुश्किल रहा.
Definitely, it's unfortunate that she had to fight the last to get the stuff done through the Supreme Court. Actually, anyway, देर आए दुरुस्त आए. At least जो अधिकार उनका था वो मिला. आप देखिए कि चारों तरफ से जो लोग उनकी जान के दुश्मन बने हुए थे, और उनसे कम से कम कुछ हद तक उनको राहत मिली. But the question is that the court should also intervene into the matter that those who are those who have the right to kill the people and openly threaten them. जो सरतन से जुदा करने की बात कर रहे हैं, आखिरकार वो मानसिकता वतन से जुदा कब होगी और आखिरकार उन लोगों के खिलाफ एक्शन कब होगा? वो मुस्लिम उलेमा क्यों नहीं बोलते? आखिर वो बार बार हिंसा को कहते हैं इस्लाम तो शांति का धर्म है, लेकिन वो जब सरपंच करने की बात करते हैं तो उन लोगों को इस्लाम से क्यों नहीं जुदा करते? आप
नहीं विनोद जी, हम बिल्कुल मानते हैं कि अगर कोई भी इस तरह की गैर कानूनी धमकियां दे रहा है किसी भी दूसरे इंसान को, कानून को सामने आना चाहिए और उस पूरे प्रोसीजर को अडॉप्ट करना चाहिए, उनकी गिरफ्तारी होनी चाहिए, उनको सजा मिलनी चाहिए. नुपुर शर्मा को आज एक बहुत बड़ी रिलीफ मिली. राशिद अलवी इज